Let's start with our today's session. Lesson number 17 we'll be doing today, which is your trademark. Very, very easy plus interesting plus scoring. So it's like piece of cake for you. Very interesting chapter, very good chapter. I hope you will enjoy this chapter. Yes, and few procedures are there. Otherwise, rest all things are very interesting to know. So please come to page number 46. So in this chapter, law relating to trademark. Okay. So first of all, what is the Indian law which governs the trademark? That internationally, though we know that there's a body, international body called WIPO, which governs the intellectual property right internationally, all over the world, and there are various agreements also which are done to protect your trademark or intellectual property right internationally, globally, in all the countries. But talking about India, which is a law in India, which is a body in India which protect trademark. So at first of all, there is a proper act passed by Parliament, Trademark Act 1999, and with respect to this, there are respective rules. That is Trademark Rules 2017. I would like to tell you that in 2010 some amendments were made. In 2010 some amendments were made in Trademark Act 1999 to bring this act in consonance with the international law, right? So in order to bring it on par with the international law, we made amendment in the Trademark Act. Why? Because we know that we are a part of international WIPO, and we have made a lot of agreements internationally, globally. So you know what, we cannot make India's intellectual property law very much independent. No, we have to make it in accordance with the guidelines formed by the WIPO. Remember WIPO? We studied in the intellectual property chapter what is WIPO, international body of the UN, which is made to monitor and administer this intellectual property rights, right? So there's a Trademark Act, and there are trademark rules. Of course, why we make this law? We made this law to provide a better protection. We made this law to provide better protection to trademark, and it extends to all of India. So this was some bakwas baat. And who's the authority of the trademark? वैसे तो there is a trademark registry, but you know what, there's only one and only controller for patent, trademark and copyright. So one single controller. There's a government website also. Um, Controller of patent, trademark and copyright. Yes. See, there's a single controller general. The name of the authority is CCPDTM. Ha 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 ha. The name of the authority is CCPDTM, which is Controller General of Patent Design and Trademark. Controller General of Patent Design and Trademark. So there's one and only authority, CCPDTM, at the central level पे जिसका office Mumbai, sorry, the office is in Mumbai. The office of CCPDTM is in Mumbai, right? So this is one and only controller of copyright, patent and trademark. Okay guys, coming back to the topic. Now, inside this there is a trademark registry as well. Okay, so now first I will give you a brief understanding about what do you understand by trademark. Right, first we'll tell you a brief understanding. What do you understand by trademark? So let's take an example. I We built a name called Yashas Academy. We worked very hard, and we provide very good quality of education, and we built a name of Yashas Academy CACS coaching, right? And we worked very hard to build this reputation, to build this reputation, to build this name. Now, don't you think this name should be protected? This name should be protected. We worked really hard. We worked really hard to provide good quality education, and we just made this brand name. We made this brand name Yashas Academy. Right now it is publicly known. We made some goodwill by working hard, खून पसीने की मेहनत. Yes, yes, we made some goodwill. Now, don't you think it should be protected? Or some era gera nathu gera, anyone will come here, any, let's say Rajnikant, not, let's not take Rajnikant, Mr. A, any random person, let's say Shah Rukh Khan, can he come and make? Mr. Shah Rukh Khan is himself very much reputed. Let's say any person, Mr. A. Can any other person, Mr. A, Samara Gera Nathu Gera, came, and now he is also providing education and saying that, oh, we are Yashas Academy, we are Yashas Academy. So don't you think he will take unnecessary advantage, or rather you can say illegal advantage of our brand name by selling in our brand name? So this should be protected. That's where the concept of trademark emerged. Please understand. Let's take another example. Okay, let's take, I'll keep on asking questions also, right, from you. So you have to post it in the chat box when I'll ask you question. So let's take another example. Um, any other example? Apple phone. Okay. अभी अभी 15 आया, right? Let's say Apple phone. Let's take Apple phone. Okay. So Apple has built a brand, a reputation, a goodwill, a brand, a reputation. कि हाँ, Apple phones are of very good quality. It has iOS, yes, and मतलब they have worked very hard and they made a brand image, they made a goodwill कि लोग Apple के नाम से people purchase phone even if it's like a 2 lakh phone, Apple 15 Pro. Yes, yes, even if it's a 2 lakh rupees phone, then also people are purchasing it because of the name, because of the brand name, or because of the goodwill they have made, right? So please understand that it has made a goodwill. Now should anyone else be allowed to use their name and to take advantage out of the goodwill they made, out of the brand name they developed? Now let's say if I want to make a phone, can I name it Apple phone, and can I sell it? No, I cannot do that, right? Trademark act will be applicable on me. No, please understand that they have built a brand name and they are famous for their characteristics of the product, they are famous for their quality of the product, they are famous for the type of the product, and not any other product should be allowed to take that name. Otherwise it will create confusion in the mind of people, it will create confusion in the mind of people. So let's say if I'll start selling a phone like making exactly similar like Apple, and 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 I'm using Apple name as well. Don't you think people will get confused that this is original Apple phone? People will get confused, or बाद में people will get to know, hi Allah, this is the duplicate phone, this is not Apple. Don't you think Apple's image will be destroyed, and I'll be using illegal advantage by taking the by using the some other person's name, by using some other brand's name in my business to make profit, and that is not allowed. This is wrong, right? So that is why the trademark is protected. Please let me know, are you clear with the basic concept of trademark? Please let me know in the chat box. Please let me know in the chat box, like why trademark is needed. Are you clear with this? Like why trademark is needed? Because to protect your brand name, to protect your brand name, right? Why yes, yes, are we clear with this, everyone? Yes, yes. Okay, great, great, great. Okay, so coming back, guys, coming coming back, please tell me one thing. I'll just give you one more example so that you get to know. Like if you know what happened, Mathura ke pede, like there was a person who was famous with Mathura ke pede, or let's say you must have heard some very 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 famous places or places to it. Like in Raipur, I'll give you one example. Srinath ki pav bhaji. You know what is pav bhaji? Ha ha ha. You must be knowing. You will be like, ma'am, please don't take any food name. Yes, we are hungry वैसे ही. तो हमारे रायपुर में, like in our Raipur, there's a famous place called Srinath ki pav bhaji. There was the first one to start with Srinath pav bhaji name, and he used to make very delicious, very tasty pav bhaji, and he was very famous. Like this became very famous. Srinath ki pav bhaji. Srinath ki pav bhaji. This name got so famous. This name got so famous. So famous. So branded. So brand name. Right? This name got so famous. Srinath ki pav bhaji. Everyone used to recommend कि अच्छा रायपुर गए हो, have that Srinath ki pav bhaji. Now this word Srinath ki pav bhaji has got so famous. The original person, let's say Mr. A. Originally, Mr. A started Srinath ki pav bhaji, but he did not take trademark protection. So what happened? You know what? All the stalls in that area, everyone started pav bhaji with the name Srinath pav bhaji. Srinath pav bhaji, Srinath pav bhaji. Srinath pav bhaji and Srinath pav bhaji. So as a result of which, now what is happening? People will get confused which one is the original Srinath ki pav bhaji, and everyone is claiming to be the original Srinath ki pav bhaji. This Mr. B is also claiming to be original Srinath ki pav bhaji. Mr. C is also claiming to be original Srinath ki pav bhaji, and Mr. D, Mr. A. all four are all four are claiming to be the true owner or the original owner of Srinath ki pav bhaji, jabki actual mein this is the owner. But customer ke liye it will get difficult to believe who is the original seller of that Srinath ki pav bhaji jo sabse pehle which became famous. But everyone is claiming to be Srinath ki pav bhaji. I am the original Srinath ki pav bhaji. I am the original Srinath ki pav bhaji. Why? Because they did not take trademark protection. That is why, when you do a business, that is why when you do a business when you do a business, that time now it's very important. If you're making a brand name or you're making a goodwill, it's very important, get it trademark registered, so that no one can copy your name or no one can use your name to sell their product. Really sorry, I'm not feeling well. um okay. Okay. So I was telling you, that is why trademark registration should be run, so that your brand name will be protected and no one will be allowed to use that brand name without your permission. So let's say if you have Nike, Nike brand name register. Nike is your brand name, it is registered, so that no one can use this without your permission. No one can use this brand name without your permission. And only original Nike shoes, only original Nike company can use the name Nike. No one else will be allowed to use this name Nike. Otherwise, it will be known as infringement of trademark. And that is why this concept came, trademark, and it is a very important concept. And if you are having a brand name, any brand name you are having, any goodwill you have made, or you're doing business under a particular name or a brand name, it's better to get it trademark registered, so that no one can copy that name. And that is known as trademark. So this was a basic knowledge. I hope you are clear about the concept of the trademark, that what is trademark. I hope you are clear with that. So coming to the book. Okay, coming to the book, first of all, important, star mark, please, star mark, definition of trademark. Of course, this can come in exam. They can ask you for 2 marks or 3 marks, like what is trademark. Yes, of course they can ask you. In that you have to write the definition of the trademark. uh, what is the definition of the trademark? So now there's a proper act, Trademark Act, and in the section 21ZB, in the section 2 clause 1 clause zb. In the section 2 clause 1 clause zb, this word trademark is defined. Are we clear with this? So trademark is defined in section 2 clause 1 clause zb. 2 clause 1 clause zb. Now what is the meaning of trademark? Trademark means, please underline, keep on underlining, highlighting. I hope you have kept your book in front of you, like the book, pen, highlighter, a yellow highlighter, blue highlighter, green highlighter, pen, everything in front of you. And don't leave it for last. Do it along with the class only. Keep the phone or the laptop, whichever thing you're watching the lecture, and open your book, open your pen, take out your pen, and start writing and highlighting along with me, okay, in your book, right? So, trademark. Section 21ZB defines the word trademark. It says that trademark means a mark capable of being represented graphically. Okay, ठीक है. What is given here? We'll see each word, and each word we will analyze or decipher in very detail. Okay. So first of all, we are saying that trademark means any mark. अच्छा ठीक है, ठीक है, ठीक है. Trademark means a mark which is capable of being represented graphically, which you can represent graphically. What does this mean? We'll do, wait. And which is capable of distinguishing goods and service of one person from another, which is capable of distinguishing your goods and service from someone else's goods and service, and includes shape of the product, includes packaging, includes combination of colors. My dear, let's just simply, ये तो trademark का logo आ गया. Let me show you different trademark. Okay. Okay, guys, very good example. Okay, see here, see here. You can see a lot of names here. Lot of names here. Walmart, yes. Burger King. How many of you like Burger King? Coca Cola. Thanda matlab Coca Cola. Honda, yes. Puma, whatever. Yes. Mercedes Benz, Nokia, CNN, BBC, Yahoo, BMW, FedEx. Yes. Harley Davidson. ये बाइक है ना, बुलेट इज दिस बुलेट क्या? आई गेस आई एम नॉट वेरी फॉन्ड ऑफ व्हीकल्स, दैट इज व्हाई. टोयोटा, स्टारबक्स, सी स्टारबक्स, IBM, HP, मोबिल, पेप्सी, all these are what? All these are trademark. So let us decipher the definition of trademark. Okay, so guys, trademark means a mark. Some mark it should be. Now the question is, what is mark? You know what? A logo can also be the mark. A name can also be the mark. A phrase can also be the mark. Image can also be the mark. Anything can be mark. Now you know what this word mark is properly defined. That what do you know by mark? Here you can see in the next page, page number 49. This word mark is defined specifically. Mark ki mark mein what all will be included? Everything like device, brand, heading, label, ticket, name, signature, word, letter, numeral, shape of the goods, packaging, combination, everything. So mark mein everything will come: name, image, word, word, letter, branding, everything and will come in the mark. So please come here. What is trademark? Trademark means a mark. Now we got to know what is mark. वैसे तो we'll do definition of mark in very detail. Which is capable of being represented graphically. Graphically meaning using graphics, using symbol, words, images. Images matlab trademark matlab you should be capable of, designing it. You should be capable of making it in the form of visual image so that we can use it. Like if you're saying that this if you are saying that this MACD M is your trademark, okay, so if you are saying that this MACD M is your trademark, show us, like, are they able to show it in the form of image? In the form of image they are able to show, right, by writing this letter M, that this is our brand name, this is our trademark. Have they taken the trademark of this? Yes, of course. Yes, of course they have taken the trademark of this. Now please understand one thing, that capable of being represented graphically matlab capable of drawn in a piece of paper, capable of being drawn in the piece of paper, capable of showing it in the form of pictures, image, visual things, so that I can see that trademark. Example, see, all these are what trademark. Android trademark, Twitter trademark, Apple trademark, logos, all these are logo, right? So all these are trademarks. So first point about trademark says that trademark means a mark which is capable of being represented graphically. Graphically means you are able to represent it in the form of image, and which is capable of distinguishing your goods and service from others. Above, you are selling a good quality phone. Let's say you are selling iPhone. Yes, you are selling Apple phones. So of course, you are able to distinguish that, yeah, Apple phones are different from other phones. Your quality is different. Your characteristics of the product is different, and by that brand name, what is trademark? If I'm using Apple, by that trademark I'm able to distinguish, and I'm able to tell customers, people, that see, this is Apple and this is Samsung, or this is any other brand. Are you understanding? Through that brand name, na, through that unique name, matlab capable of distinguishing goods and service from others, matlab it should be unique. It should be unique. It should be unique, so that people get to know, ha, that this brand is different, that brand is different. Are you understanding? Boat headphones. Boat, is it something unique name? Unique name, yes, of course. Boat is a different word. Headphones and electronics are the different word, right? So boat. When you say boat headphones, right, you are able to distinguish how boat is a separate brand, Sennheiser is a separate brand, okay, or let's say Skull Candy is a separate brand. So you are able to distinguish boat by using the word name boat. You are able to distinguish it from the goods and service of another brand. Why? Because this is a unique name. Yes, so trademark should be something which should be capable of distinguishing your goods and service from others. Example, can I register a glass? Can I register a glass as the trademark? No. Why? Because glass is a common word, right? It's a product name. If I simply use glass as the trademark, this trademark, this word or this mark is not able to distinguish my brand from the other's brand. So I cannot register this as a trademark. So capable of distinguishing goods and service, matlab it should have a unique name, so that people recognize you by that name. Are you understanding? Let's take an example. Can we register Yashas Academy? Can we register our trademark with the name of Best Academy? Can I make an academy called as Best Academy, right? I made a I made a mark. I said that, okay, my academy name is Best Academy, Best Academy, and now I'm applying to the registrar, to the trademark registrar, to register this name Best Academy as the trademark. You know what government will say me? What trademark registry will say me? Trademark registry will say me, madam, this word Best Academy, you don't have any unique name here. This word is this word is not able to distinguish your product or your brand name from the other's brand name. This word is not able to distinguish between your academy and the other's academy. So if I'm just using a very good example, if I'm just using the word CS Academy, right? CS Academy. CS Academy is a very common name. It just shows the work that we are doing, right? If I want to register CS Academy as my trademark, if I want to register CS Academy as my trademark, I cannot do that, because it is not able to distinguish my uniqueness. It's not able to distinguish my goods and service from someone else's goods and service. So that is why it's not a trademark. Trademark should be something you can get only those words or those phrase or logo as a trademark, which is your unique thing, which is unique for you, which is different from your competitors' product and service, through which we'll be able to distinguish between your product and service. Samsung is a different name, unique name. So they have registered Samsung as the trademark. So it shows that, yeah, Samsung is a different phone brand, Apple is a different phone brand, Realme is a different phone brand. Are you understanding? I hope you have understood till now that this definition is very important. The definition of trademark given in section 21ZB, which says that it means any mark which is, number one, capable of being represented graphically. Matlab you are able to represent it in the words and images, and matlab both the conditions should be satisfied. And which is capable of distinguishing goods and service of the one person to another. We are capable of distinguishing our product and service from the other's product and service. And trademark also includes shape of the goods. Now shape of the goods में I'll give you very good example. You know, have you had melody? ये melody इतनी चॉकलेटी क्यों है? ये melody इतनी चॉकलेटी क्यों है भाई? Have you ever asked this question to anyone? ये melody इतनी चॉकलेटी क्यों है? So if I talk about melody, you know this chalk. Have you had this melody? How many of you like melody? You'll be like, ma'am, don't show us. Gift us. Ma'am, don't show. Gift us. Gift us melody. Yes. Yes. How many of you like melody? Yes. Have had it, ma'am. Preeti is saying I like melody. Okay, Sharath, have had it. Okay, so talking about the shape of the goods, you know this shape of the melody, this rectangular shape having this line thing. They have got a trademark of the shape. Ki no other chocolate they can make with the exact same shape. You know, with this shape only, you know, even if you, let's say you have not seen the packaging, even if you see the open chocolate with this shape, now you will understand this is melody. Why? They have taken the trademark of their shape also, that this rectangle chocolate, this kind of rectangle chocolate with a line in that, they have literally taken a trademark on this shape of their chocolate, on the shape of the chocolate, that no one else can make exactly the same shape of the chocolate, shape of the goods, shape of cars, yeah, design of cars you get trademark, shape of iPhone, you know, iPhone has taken trademark for the shape of iPhone. No other phone brand can make exact same, like, you know, this curved edges which iPhone have. Okay, so this no other brand can copy this. No other brand can copy this exact same shape. No other phone can make the same shape. You know, the Apple iPhone shape is different, and Android देख के अलग से, you know, how this is Android. iPhone देख के अलग से, you know, even if you don't see the Apple mark, then also, you know, iPhone shape is different. By seeing it, you'll get to know this is iPhone. Apple has taken the trademark for the shape of the goods. So my dear, can the shape of goods also be trademark? Yes, of course, shape of the goods can also be trademark, including packaging. Ma'am, can packaging also be trademark? Yes. Have you seen this Nivea bottle nahi, Nivea dabbi, whatever we call this? Yes, Nivea box, Nivea packaging. And if you talk about the packaging thing, right, you know, they have done the trademark कि ऐसी packaging कोई नहीं करेगा. No one will copy our packaging. You know, like this blue dabba and this round dabbi, choti si, blue and white color Nivea cream. No other cream company can copy this exact same packaging. Are you understanding? You know what? You can get your packaging. Coca-Cola. Coca-Cola. वैसे तो, you know, they have taken the trademark on the base of design, but the bottle shape of Coca-Cola is trademark registered. Do you know that? Like this bottle shape of Coca-Cola, this bottle shape like this, I don't know if I'll be able to draw it or not. You'll be like, मैम आपसे इंडिया का मैप तो बनता नहीं है, आप कोको कोला की बॉटल क्या बनाएंगे? ठीक है, you cannot make fun of me. I can make fun of myself. Okay, so coming back to the topic, let's make I hope I'm not making something else. GR. Let's try once again. Let's give it a try. ओ भाई कितना डिफिकल्ट है ये. You know what? I'm an artist. No, you will laugh. I hope it's fine now. हाँ देखो, I made it correct. I made it correct. हाँ. Yes. Yes. This this shape of bottle. This shape of bottle. No other. You know, Pepsi. If you'll see, there is a Nivea in our class, ma'am. Haha, yes, there's a Nivea in our class as well. But unfortunately, she's not here because she's an old syllabus student. So if you see this shape of bottle, shape of bottle, the packaging of the Coca Cola, how they package in this Coca Cola bottle. No other company can copy this exact same shape of this bottle. This shape पहले इधर थोड़ा सा बाहर है, and then again थोड़ा सा बाहर, मतलब this shape of the bottle no one can copy, no brand can copy this exact same shape. So packaging also, you can trademark क्या? Yes, packaging also you can trademark. And third is combination of colors. Again, combination of colors में I'll give you the Nivea example. Same combination of color में, if you see this blue and white combination, this navy blue and white combination, if you see this navy blue and white combination, my dear, they have taken a trademark of this combination of color. Ki no other cream brand company or the cosmetic company, cream company or any cosmetic company, no other cosmetic company can use the same packaging. Now you'll say Cadbury to also uses blue and white, so it's a chocolate company. Now trademark is registered with respect of a particular class. Trademark is registered with respect of particular class. So please understand that here, they have taken a trademark of the combination of color, that after detailed analysis we came across this combination of color blue and white. Now no other cream company can come and make this blue and white dabbi. You know what, even if they are using some other name now, even if we don't see the name, the moment we see this blue and white dabbi, the moment we see this blue and white box, we automatically Nivea comes to our head. It is so famous. Some brands like MACD, yellow color. Yes, MACD, that yellow color, but yellow color. They have this trademark of the color also, that no one else can use this exact same color, like this orange and yellow color. No one else can use this exact same color while making a food, or in whichever category they have taken the trademark. Now, please understand that, ma'am, combination of color also we can trademark. Yeah, yes, combination of color also you can trademark. Here, of course, they have made a very good brand image. They have good an image. They have made an image of themselves. They have made a brand name of themselves, that if anyone hears this word, anyone sees this bottle blue and white dabbi, they automatically Nivea comes to their head, that yeah, this is Nivea cream or this is Nivea product, because they got so famous with this blue and white thing. So why someone else would be allowed to take advantage of this? Because if we will not take a combination of color trademark, everyone will start making their bottles blue and white, and this will create a confusion in the mind of customer, that which one is original Nivea. If they don't read the name, by just seeing the bottle, they'll get to know, they'll have an assumption in their mind that this is Nivea bottle. So that is why the combination of colors can also be trademarked. These two lines you can cut. Now I hope that the trademark definition is crystal clear to you, and you can easily learn and by heart the definition of trademark. Once again, I'll say trademark has been defined in section 2 clause 1 clause ZD, which says that it's a mark capable of being represented graphically, and which is capable of distinguishing goods and service of one person to another, and includes shape of the goods, packaging, and combination of color. I have just explained each and every word in this particular definition. I hope that this is crystal clear to you. Now, simply the simple general meaning. The general meaning of trademark is given, which we have already done. Trademark matlab, since you can say your brand name, your your brand name in a layman's language, or visual symbol, which may be a word. Trademark can be a word, trademark can be signature, trademark can be your name, device, label, numeral, or combination of color. Let's take example. Any word can also be the trademark. Example: Gmail, Puma. Puma is a word. Puma. Yes, Puma. So Puma is a trademark. Yeah, yes, Puma is a trademark. So this word Puma, can you get any word as a trademark? Yes, of course. Google bhai. Google bhai has trademark. Google. You cannot use Google without Google's permission. Yes, if I make any other browsing website, or any other cloud, cloud data thing, or the browser thing, can I use the word Chrome or Google? No, I cannot use that. That word is properly trademark. So the word Gmail, the word Puma is trademarked. Are you understanding? This is the example of word. Ma'am, logo can also be trademarked. Logo example, this M sign. This M sign is a logo. Logo can also be the trademark. Example, Yashas Academy ka logo like this. Arey, nahi, wait. something like this, something like this. Or logo, different kind of logo. Nike ka this stick, Nike ka this stick. Yes, no other shoes making company can make the same tick and sell the shoes. So Nike ka this stick, you can say, is a logo. Logo can also be trademark. Phrase can also be trademark. MACD, I am loving it, I am loving it. This phrase can also be trademarked. No other, like now if Burger King want to use this phrase, can Burger King use this phrase, I am loving it? No, Burger King cannot use this phrase, because this phrase is trademarked in the name of MACD. Are you understanding? I am loving it. Have you heard it now? MACD, McDonald's. I am loving it. This in ad also this comes. I am loving it. So this is a phrase. Can you get a phrase also as a trademark? Yes. Pepsi ka. Oh yes, abhi. Oh yes, Pepsi ka. To there are more. Pepsi thi pi gaya. If you have heard it, all these are trademark. Coca Cola ka. Arey, uska thumbs up. Thumbs up. थम्स अप की माउंटेन ड्यू, डर के आगे जीत है. यस, माउंटेन ड्यू, डर के आगे जीत है. अमूल दूध पीता है इंडिया. Yes, you might have heard about all these phrases and all. So can you get this phrase also trademark registered? Yes, you can get phrase also trademark registered. Next is symbol. Let's say here in Jaguar we use the symbol. Can we get any symbol also as a trademark? Yes, you can get the symbol also as a trademark. We can use image also as a trademark. Amul. Amul, have you seen this girl of Amul? Parle ji ki girl, you have seen Parle ji ki. This is an image. They have researched a lot, and after a lot of designing and all, they made this image. They made this brand image. They made this brand image of Amul, where a girl is having a bread and applied Amul butter in that bread. And this girl, no other brand can use this girl. Why? Because this girl is trademark registered. The image of this girl, can you get image also registered as trademark? Yes. Example, this is some paint company. I don't remember which company. But yes, Amul Parle Ji Girl, I'll show you. Parle Ji Girl. पार्ले जी का लोगो नहीं, पार्ले जी का, हाँ हाँ हाँ. दिस गर्ल यू हैव सीन, दिस गर्ल सो क्यूट. पार्ले जी की गर्ल काउंटिंग फिंगर्स लाइक दिस. ठीक है जी, माने जीनियस. पार्ले जी, दिस गर्ल, शी इज trademarked. No one else can use this image of this girl in their biscuits. Are you understanding? Or in their product. This girl is trademark registered. This girl image in Parle Ji. You must have seen that, right? So you know what? You can get image also registered as trademarked. Yes, shape of your product, or like design of your product. As I told you, Coca Cola bottle is designed alag se ekdam. The shape is different, and beech mein aise linings are there. The shape of Coca Cola bottle is completely different. No other juice making company, or a beverage making company, or a soft drink making company can make this exact same shape of the bottle, because this design of the bottle also we have done trademark. Symbol can also be the trademark. Example, Nike, Apple, this Mercedes brand. Yes, this Mercedes shows the represent air, water, and land. Yes, this three logo. Every logo has some meaning. Every logo has some meaning. Right? The symbol can also be the trademark. So anything can be trademark, my dear. A word can also be the trademark. Please understand. Um, your word Puma. Signature can also be the trademark. Signature ke liye I'll give you example. Taylor Swift. She's an American singer. Yes, and music composer. So Taylor Swift. The word Taylor Swift, her signature, she has done trademark. She has registered trademark of her name, Taylor Swift. Her signature is trademark registered. No one else can use her signature without her permission, or her name or signature. Signature also you can get trademark registered. Yes, of course, yes. Your name also. Your name, Ishika Agrawal classes. My name, can I get trademark registered? Yes, Ishika Agrawal. Name, you know what? I'll give you a very famous example. SRK, Shah Rukh Khan. You know what? Shah Rukh Khan has registered his name as the trademark. Yes, if you see, SRK name is registered as a trademark. SRK, Shahrukh Khan, this word is registered as the trademark. You know why? Because a lot of people in India now, Shahrukh Khan is a public profile, right? Shahrukh Khan is a celebrity. So Shahrukh Khan is a celebrity, and people in India now try to make misuse of it. Why? Let's say I opened a small acting academy here in Bangalore and I named it SRK Academy. Can I do that? You know, it gives a false image to public that this academy is run by Shahrukh Khan, but actually this academy is not run by Shahrukh Khan. But I'm using Shahrukh Khan's name, SRK Academy, Shahrukh Khan's Academy. Can I do that just to promote my academy? No, I cannot use his name. He has built his name by working hard. Shahrukh Khan, SRK. He has made it his image. He became celebrity by working hard. Now just because of he's famous, just because he is a famous celebrity SRK, I cannot use that name to make profit, to do my business, to grow my business. अपना नाम से academy बनाओ, इशिका अग्रवाल academy. If you want to provide acting classes in actual way, many people started making their shops, running their businesses in the name of SRK or Shahrukh Khan, just to promote their sales, to create an illusion in the mind of public that this is this academy or this business is related to Shahrukh Khan. So Shahrukh Khan have actually registered his SRK and Shahrukh Khan as his trademark. No one can use this word SRK. Let's say I'm starting an acting academy. I'm starting with the word SRK Academy. SRK can file a case against me. I cannot use it without the permission of SRK. Even this Sachin Tendulkar, SRT, Sachin Ramesh Tendulkar. He has also taken the trademark of SRT. If I'll be telling you, he has also, and Akshay Kumar has also taken a trademark in the name of Khiladi Kumar, because he has because he has, I hope you know all this Bollywood celebrities name. You'll be like, ma'am, we don't watch Bollywood, we don't know who is SRK. Acha, Sachin Tendulkar to cricket fan to everyone know. Akshay Kumar, I hope everyone knows Akshay Kumar. Don't say that, ma'am, we don't watch Bollywood. Okay, so Akshay Kumar made a lot of movies with the name Khiladi, so that is why the word Khiladi Kumar he took as a, he registered as a brand name or a trademark. He registered as a trademark. No one can use that without his permission. So your name, my name, let's say I become a public profile. Tu. God, please bana do na. ठीक है, let's say I become a public profile. Okay, so now everyone knows me, Ishika Agrawal. So can I get my name as the trademark registered? Yes, I can get. Now no one else, let's say I made an academy and it became very famous, all over India famous, I became a public profile, Ishika Agrawal. Now can anyone start an academy with the name Ishika Agrawal classes? No, it will be infringement of my trademark, right? So I can get my name also as a trademark. Any device, device picture, example, windows may, they make this actual make this windows, and they use it as a trademark. So any device also you can register as a trademark, of course. Yes, device also you can register as a trademark. Any label means anything written in numbers or in letters, even numerals can also be the trademark. Example, this Volkswagen. Yes, Volkswagen, if you'll see the logo of Volkswagen, what is this? Nothing but a two letter. They have simply written a W, and in this W there's a hidden V. Hidden V, like here. This is a hidden V in W. So Volkswagen, and this you can say two letters they have used to make the logo of Volkswagen. If I'll show you more, uh, numbers, mein I guess I had more pictures. Where it gone? हाँ, अच्छा नेक्स्ट पेज में होगा. Yes, numbers में, numbers में भी you can get numerals also as a trademark. Numerals means number. Example, girls must be knowing this fashion brand Forever 21. Forever 21. Girls must be knowing this fashion brand Forever 21. This Forever 21 is registered as a trademark. Can I make this can I use this word 21 and I can I make another clothing brand? No. 7 Up. 7 Up. 7 Up. So this 7 Up is using the number 7. Cloud 9, cloud storage, they provide cloud 9. So the box 8, G20. A lot of words are there, brands are there, which uses just a letter or a number as a logo. Netflix ka logo is simple one letter N. Simply one letter. And this N, red color ka N, they have registered as a trademark. You cannot use the same, and this same red color ka N, and you can make another OTT platform. No, this red color ka and just a letter, they have taken a trademark for this. HP, just two letter, simply written HP with white color with a blue background. Yes, they have taken a trademark of that. Simple, any letter, any number also you can get as a trademark, you can register as a trademark. Now coming back to the topic, बहुत ज्यादा खिचड़ी पक गया है, बट ठीक है, आई होप यू आर राइटिंग द एग्जांपल्स एज वेल. लेबल, न्यूमरल्स और कॉम्बिनेशन ऑफ कलर. कॉम्बिनेशन कलर का एग्जांपल आई हैव ऑलरेडी प्रोवाइडेड यू विद द एग्जांपल ऑफ कॉम्बिनेशन ऑफ कलर, राइट. यूज्ड बाय वन अंडरटेकिंग ऑफ which is used by one undertaking of goods and service or articles to distinguish it from the other similar goods and service, right. So that is the general concept of trademark, which any mark, logo, device or numbers or word or symbol we use in our business, in our goods and service, to distinguish our goods and service from our competitors goods and service, that is trademark. And this is the general meaning of trademark. So in case the question comes what is trademark in examination, you can write this definition also, you can write this definition of trademark also, you can write this general meaning of trademark, general meaning of trademark. So now please come to the next page, and please come to next page, and page number 49, and here you will see in the section 2 clause 1 clause M, the word mark is defined, because trademark means a mark, right. So the question is what is mark. वैसे तो I have already told you, but ठीक है, once again see, anything can be mark, everything will come here. You know what, everything will come here. What is mark? Device, like I gave you this Windows example, device can also be a mark. Brand can also be the mark. Any heading can also be the mark. Label means anything written in the piece of paper, anything can be a mark. Ticket मतलब, ticket का example I'll give you. Let's say ticket. I had some example in my mind, not able to recall it. Uh, some brands, they provide ticket, and their ticket are like unique. Their ticket are like unique. The ticket shapes, whatever. Let's say this is the ticket. Some design is made in the ticket. So you can get a ticket also. Let's say you are selling book my show tickets, that ticket also can be registered as a trademark. Your name example Saruk Khan, I already told you. Signature Taylor Swift example. Any word Puma. Letter W is registered as a Volkswagen, right. Letter M is registered as a McDonald's, right. Any number, any letter or any number. I just gave you example of 7 up. 7 up, any number can also be registered as a trademark. Shape of the goods, I told you, I gave you iPhone example and melody example. Packaging mein and combination of color mein I gave you example of Nivea. So anything can be marked, my dear, anything. Device, brand, heading, label, ticket, name, signature, a word, letter, numerals, shape of the goods, packaging, combination of color, anything can be marked. Anything can be marked. Are we clear with this? I hope we are done with the definition of mark. Now coming back to the topic, this is also a general point given that what are the essential requirements to register a trademark, and this is nothing new, but they have given this from the definition of trademark only. So if you'll recall the definition of trademark, the definition of trademark says that it is a mark which is capable of being represented graphically and which is capable of distinguishing your goods and service from the others. So three conditions should be fulfilled. Three conditions should be there in order to register your trademark. I want to register Ishika Agrawal as a trademark. Three conditions should be fulfilled. Three conditions should be fulfilled. Number one, it should be some mark capable of being represented graphically. Graphically matlab in the paper form. Paper form matlab you should be able to write it or draw it in the paper. You should be able to present it in the visual form using images or words. Are we clear with this? So number one, it should be capable of being represented graphically. Number two, it should be unique. Unique matlab it should be able to distinguish your goods and service from your competitors goods and service. It should be capable of distinguishing goods and service of one undertaking from another's undertaking. It should be unique. It should be able to distinguish your brand from your competitor's brand. Are we clear with this? And third, Third, it should be used or proposed to be used in relation of goods and service for the purpose of indicating or as to indicate connection in the course of trade. ठीक है. Third condition. What is the third condition? The third condition is saying that, let's say I have taken a melody. I have taken this melody trademark, right? The shape of the goods as a trademark. Now this trademark I can use only in respect of those goods and service relating to my business, relating to my trade, for which I have taken the trademark, for which I have taken the trademark. So my dear, it should be used only for those business, it should be used only for that business or that goods and service for which you have taken the trademark. So trademark should be used, if you have taken a trademark, it should be used or proposed to be used only in relation to goods and service, goods and service in relation to course, in connection with the course of trade between goods and service, and some person have the right to use that mark which are without, with or without identity of that person. Example, I'll give you one good example. I'll give you, there's a, company called Nestle. Nestle ki Maggie. Maggie is not a company name. Maggie is not the owner. Maggie is just a brand name. I'm really sorry. Okay. um, Till now I had only cough, but yesterday I got cold also, cough also, fever also, like all three at the same time. I got cold also. Earlier I had only cough. Now there's a cold also, fever also, right? But we cannot skip the classes as of now, so I'm able to take class. But I hope you are okay with the disturbance thoda sa which is being created in the class. I hope you are able to adjust with that. I'm really sorry for that. Okay. Yes, so coming back to the topic, Nestle ki Maggie. So if you see now, the actual company name, the owner of this brand is Nestle, and the brand name is Maggie. The brand name is Maggie. So Maggie is the owner. Kya? No, Maggie is just a brand name which is used for Nestle ka business. Nestle ka noodles, what they make, Nestle ka noodles they make, and that is used, and Maggie can be used as a brand name in that only. Now here. Even without the identity of owner, even without the identity of owner, in respect of Nestle's noodles business, they can use this trademark Maggie. So this is what is given in the third point. Three requirements are there in order to register a mark as a trademark. Number one, it should be able of being, it should be some mark, it should be some mark which is capable of being represented graphically. Point number one. Point number two, it is you are capable of distinguishing your goods and service from someone else's goods and service. Point number three, it should be used or proposed to be used in relation to goods or service. Use, don't use. You are proposing to use that trademark in relation to your business, not for your personal use. Are you understanding? You are proposing to use that mark or trademark in relation to goods and service which is connected to the course of trade, meaning which is connected to your business. I hope everyone is crystal clear with this. This also you can write in case the question comes for the 5 marks, like what is trademark. This also you can write. So we are done with this. Now certification, collection, and well-known trademark. Okay. 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 Now come to certification, trademark. These two are the new term. Listen very carefully. Listen very carefully. You can take a screenshot as well. Is there any facility to take screenshot in the Zoom? I am not sure. But if you're able to take, you can take screenshot. If you're able to take, I'm not sure whether your screenshot is allowed or not, but you can try taking the screenshot of this. Okay. Yes. So coming back to the topic, there are three types of trademark that you have to study. One is your certification trademark, another is your collective mark, and third is your well-known trademark. So I'll try to explain this. First, I'll explain you well-known trademark. Well-known trademark means, which is very famous, super duper famous, like Google, Apple. Yes, all these things are super duper famous, super duper all over India. It is famous. Are you understanding? Reliance, which is famous even cross border, matlab globally. Globally also that brand is very much famous. Then we call it well known trademark. Well known trademark. Avik Lavit is something which is any brand which is known to significant, substantial segment of public. Like if you'll take example of Nandini milk. Nandini milk is consumed here only in Bangalore, right? Nandini milk is not consumed in north, it is not consumed all over India, so everyone knows about it, can know. So will not call it well known trademark. Well known trademark, which which is famous all over India, which is famous even outside India, which is famous worldwide. Infosys, yes, yes, IBM, you can say all these are well known trademark, you can say, which are known to a most majority substantial segment of public. Substantial matlab significant, even थोड़े ज़्यादा amount of public they know about this trademark, then we will call it a well known trademark. Okay, so Section 2, Clause 1, Clause 2G defines well known trademark, which says that well known trademark in relation to goods and service means a mark which has become known to the substantial segment of public. Any mark which is known to substantial segment of public, like majority of public know about this already, then we can call it a well known trademark. Everyone knows about Google, everyone knows about Facebook. Are you understanding? Everyone knows about Reliance. So no one will say that even those who are not good, those who don't watch news and all, they even know Reliance Mukku Bhaiya, right? So Mukku Anna. So we can call it a well-known trademark, means which is known to the substantial segment of the public which uses goods and service, such that the use of such goods and service in relation to other goods and service would be likely to be taken as indicating a connection in the course of trade or rendering service between those businesses using the mark in relation to first mention. इतना सारा क्या लिख दिया, इतना बड़ा सारा paragraph. Here simply one point is given that well known trademark means famous trademark, a trademark, a mark which is known to substantial segment of public, and if we allow using that mark for any other goods and service, for any other goods and service which is not our goods and service, then it will create an illusion in the mind of customers that that other goods and service have some connection with the first mentioned goods and service. Why? Because we are using the same mark. Are you understanding? So no one else would be allowed to use your trademark. So well-known trademark means a mark which is known to the substantial segment of public. Now you can come here if you want to register a well-known trademark, then you have to apply to the registrar. In for trademark here we have a registrar in India for trademark registration. Now वैसे तो there is a controller के अंदर controller of patent trademark copyright is there, controller general. under controller under controller there is a trademark registry, that is Indian trademark registry. There is a trademark registry, registrar, you can say, who registers the trademark on behalf of you. So there's a trademark registrar. Are you clear with this? So my dear, here one point is given. If I want to register my trademark as a well-known trademark, I'm applying to the government, you know what, I'm famous, my trademark is a well-known trademark, please register this trademark as a well-known trademark. So in that case I have to make an application in the form TMM. The form number is TMM. The form number is TMM. So I have to apply application in the form number TMM, make request to registrar. My trademark is famous, please declare this mark as a well-known trademark, and then they will do the searching and all, they will do checking and all, and if they are satisfied that yeah, this is actually well known, then they will register my trademark as a well-known trademark. Now see the second highlighted point of the see the second point. Well-known trademark are recognized in India on the basis of their reputation, nationality, nationally, internationally, cross-border. See, national reputation matlab you are known in India only, you are famous in India only, you are not famous outside India. Internationally and cross-border matlab you are not famous only in India, you are famous all over the world, even outside India also, in China, Japan, other countries, right? America, Australia. So here one point is given, well known Trademark means a trademark which are famous globally, in India, outside India, internationally, cross border, have the reputation. I hope you're clear with this. What is well known trademark? Well known trademark are registered, recognized in India on the basis of their reputation. We check their reputation. What is their reputation nationally? India mein what is their reputation? Globally and internationally and cross border, what is their reputation? All these things we'll check before giving them registration as a well known trademark. And see this last highlighted point, well known trademarks have its goodwill, reputation protected across the nation and across the category of goods and service. So if I'll call well known trademark, if you are famous all over the India now, then you can register your trademark as a well known trademark. So well known trademark means you have got a goodwill. Let's say Amul Doodh. Amul Doodh, if you will say Amul, Amul is a brand, and their ad only says that Amul Doodh pita in India. So if you talk about Amul, Amul is famous all over India kya? Yes, of course. Amul is famous all over India. It has a goodwill kya? Yes, people purchase Amul milk. बोल के दे परचेज अमूल का ही घी चाहिए, अमूल का ही बटर चाहिए, अमूल बटर ओनली. Yes, so it has a goodwill reputation. Yes, of course it has. हल्दीराम, हल्दीराम, very good reputation. और कोई भुजिया नहीं चाहिए. We don't want any other bhujia. We want only हल्दीराम भुजिया. We want only हल्दीराम save. Yes, so well-known trademark matlab it have a goodwill, which have a reputation across the nation, across all over India, in respect of particular category of goods and service. That is known as well-known trademark. Example: Google is a well-known trademark of Alphabet Inc. Google is trademark. The company name is Alphabet Incorporation. The name of the company is Alphabet Incorporation. Alphabet Incorporation owns Google. Alphabet Incorporation owns Google. Are you understanding? So Google is a well-known trademark. Of course, yes. Google is a well-known trademark, cross-border trademark, you can say, which is famous in the country, globally, whole world. So this is the concept of well-known trademark. I hope everyone is crystal clear with the well-known trademark. Now, next, I will tell you collective mark. What is, listen very carefully, it is something new, it is something which is new for you, but listen very carefully. I'll try to justify this topic so that you understand clearly what do you mean by collective mark. Do let me know whether you are able to understand or not. Collective mark, let's just read over the material. Collective mark means a trademark distinguishing goods and service of members of association of person not being partnership within the meaning of Indian Partnership Act, which is the proprietor of the mark from those of others. नहीं समझ में आया? कुछ नहीं समझ में आया, राइट? कुछ भी नहीं समझ में आया. Understood or not? No, ma'am. ये पढ़ के तो we understood nothing. Now, don't worry, I'll explain you. Collective mark means, which is not your mark. Which is not your mark. Which is the mark of an association, organization. Example, CA, CS, CMA. CA, CS, CMA is a very good example. If you talk about CA, if you talk about CS, is it your mark only? It is my mark only. Can I say that only I can use CS? No other person can use CS. CS is my trademark. Yeah, no. CS is not my trademark. Is CS my trademark? No. CS is a collective mark. Collective mark means it is the mark of ICSI. Like ICSI is what? ICSI is an organization. ICSI is the organization, it is the body, and the trademark CS. The trademark CS, this exact, this two words which you see, CS. So this particular trademark CS, this trademark CS is a collective mark of the whole body ICSI. Now everyone who is the member of ICSI can use this trademark. So I am member of ICSI, can I use this trademark? Yes, ma'am, I can use this trademark. Are you understanding? Are you understanding? What do you mean by collective mark? What do you mean by collective mark? Collective mark does not belong to individual person. No, collective mark does not belong to individual person. Collective mark belong to organization. Collective mark name itself says collective. Collective. So collective mark which belongs to a body, which belongs to association of person. So if I talk about CS, CS is a mark which is owned by ICSI, 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 collective mark, and it is able to distinguish its. Just a minute. Like ICSI have registered a trademark CS. Now everyone who is a member of ICSI can use this. But in order to use this word CS, you should be the member of ICSI. Let's say you are the student of ICSI. Can you use the prefix CS? No. As of now, you cannot use the word prefix CS. But after becoming CS, then you can use CS in your name. Why? Because this is a collective mark. Only those who become the member of ICSI, only they will be allowed to use this mark CS. Are you understanding? That is collective mark. Here you can see collective mark is owned by organization used by its member. It is owned by organization, but organization does not uses it. Like, although this term CS is owned by ICSI, but ICSI don't use this CS. Of course, people who are member of ICSI, they use this designation CS in front of their name. Are we clear with this? That is collective mark. Now read again, now you will understand. Now read again, now you will understand. Collective mark means a mark. Collective mark means a trademark. Collective mark means a trademark which distinguishes goods and service of the members of AOP. Members of AOP. This mark is not of an individual person. This is not, CS is not my trademark. I have not registered trademark, CS trademark in my name. But this is the trademark of ICSI, which is association of person, which is a body. I am the member of ICSI. I am the member of that association of person, and I can use that to distinguish that yes, I am different. I am a CS, different from a normal individual. Are you understanding? So it's a collective mark which is used for distinguishing goods and service of the members of association of person. But that AOP should not be partnership. Okay, it can be company, it can be any other body, body corporation, but it cannot be partnership. So other than partnership, which is the proprietor of the mark, who is the, that AOP is the owner of the mark. Proprietor means owner, now already. Proprietor means owner. So owner of the mark from those of others. Association, and that AOP is the owner of the mark. I told you, if I talk about CS, I'm using the trademark CS, but I'm not the owner of CS. ICSI, which is AOP, Association of Person. ICSI is the proprietor of this mark. ICSI is the owner of this mark. I hope everyone is crystal clear with the collective mark. The last one is certification trademark. Certification trademark says that you can use this trademark only if you comply with their certification, only if you comply with their requirement, their certificate. You are certified by that brand. Example, very good example. This when you make any food item or something eatables, right, you either use this green dot or red dot. Green dot says that it is a vegetarian, and red dot says that it is non-veg. Green dot says that it is veg, red dot says that it is non-veg. Now please understand, क्या ऐसे ही अपने मन से I can use the green dot or the red dot in my food packet? Let's say if I have any food packet with me, can I ऐसे ही I can use green dot or red dot? No. In order to use green dot or red dot na in your packet, you have to apply to our food authority, and they will do the checking. They will do the checking. Let's say I want to use green dot in my biscuit packet. In my biscuit packet, I want to use this mark. What is this mark only na? This green dot, this green dot is a mark, right? So if I want to use this green dot in my, let's say, biscuit packet, I'm making a biscuit, or let's say I'm making a melody chocolate, right? I'm making a melody chocolate. Now in this packet of melody, जो outer wrapper आता है ना उसमें, the outer, in the outer wrapper of the melody, I want to place this green dot. But you know that in order to place that green dot, I have to apply to the food authority. They will do the checking whether it is actual mein pura pure veg or not. There is no egg, there is no non-veg in this. Then only they will certify. They will certify that this product is good, this product is veg only, in this no non-veg is used, and then only they will allow me to use this word, green mark. Are you understanding? Acha, am I owning this green dot? Only I can use this green dot kya? No, I'm not owning this. This is not owned by me. This green dot is not, this mark is not owned by me. Are you understanding? This is owned by government body, or you can say a proper body. But they are allowing me to use this green mark on their permission, because I am complying with their requirements. Are you understanding? Like FSSAI, like this, you have seen this Bismarck in gold jewelry, in the gold jewelry, nowadays तो अभी तो नया नया mark has come in the gold jewelry, new 6 digit hallmark. हाँ, hallmark, very good example. Hallmark, Hallmark is a very good example. Is it owned by me? No. Let's say I'm a person who sells jewelry. I am the person who sells jewelry. I'm selling jewelry, gold and diamond ornaments and all. Now there is a regulation which says that in order to justify the purity of the gold, in order to justify the purity of the gold, that your gold is pure, 100% pure, it should have this 6 digit hallmark ID in it. Earlier it was 4 digit, now it has been made 6 digit. So anywhere, anytime you want to purchase gold, let's say you're purchasing gold, or like a gold, it is a gold bangle, right? So it should have that 6 digit code, hallmark code, 6 digit hallmark code in that ornament, in that gold. You know why? It shows purity. It shows purity of the gold. You trust that. When you see the hallmark logo, or the hallmark in any gold, or any this kind of metals, gold, silver, jewelry, diamond, so it you trust it is pure. Aise to you doubt whether, what if the shopkeeper is selling me nakli gold, artificial jewelry, telling that this is gold, it is not original gold, and they are selling me artificial jewelry. So there's this doubt in my mind, and before purchasing a gold. But as soon as you see this 6 digit code, hallmark verified, matlab hallmark has verified that yeah, this is actual mein pure gold. This is there is no mixing matching in this. There's no duplicate thing or artificial thing. Everything is pure gold. Then only they will give this logo, hallmark logo. So as soon as I see this hallmark logo in the any gold, I will be assured that yeah, this is hallmark certified. This is certified by hallmark, matlab hallmark had does the checking and all, and it complies with the requirement. It complies with their requirement, and this gold jewelry have taken a certificate from them. It shows the purity of the gold. Are you understanding? That is known as certified trademark. Example, this BIS logo, you can say again, this suggests the purity of the gold. This BIS logo and hallmark, it is used in jewelries and all, gold and all this thing. Are you understanding? Yes, example, ISI mark. This is used in industrial product like steel and all, right? To guarantee their quality. ISI word is used in industrial product. Are we clear with this? Yes. So all these are known as certified trademark. Certified trademark means, you can use that trademark only if you comply with the requirement of that particular trademark, requirement of the property of trademark. You have to take a certificate from them. Example, in order to put the BIS logo, BIS logo, or the hallmark logo in my gold jewelry, I need to take a certificate from hallmark authority, and they will check the quality. They will check my gold. They will check the quality of my gold accuracy, and then only they will allow this using this BIS logo in my gold jewelry. Are we clear with this? Now, certified, if let's say I'm selling a gold, and I'm using this BIS logo and hallmark logo, is am I the owner of this BIS logo, hallmark logo? No, I'm not the owner. Owner is someone else. They are allowing me to use this logo because I comply with their requirement. Please understand that what is certification trademark? It is not my original trademark. No, I have not taken this trademark. I have not registered this trademark. Hallmark trademark is also already there by the hallmark authority. They are the proprietor of this trademark. They are the owner of this trademark, but I can use this trademark, I can use this hallmark trademark with the permission of the hallmark authority, by getting a certificate from them. And if they allow, they will do the checking. If they allow, then I can use that trademark. So if I'm using this green dot red dot FSSAI trademark, or the BIS logo, or the hallmark logo, ISI logo, or all this thing, eco mark, etc., in that case I need to be certified from that authority. Then only I can use this. Acha, once again, is this my original trademark? Have I registered this green dot and red dot in my name? No, I have not registered this in my name. This is taken by food authority, but they allow me to use this mark if I comply with their requirement. I hope no further explanation is required. Now if you'll read this, you will understand. Otherwise, without explaining or without example, if simply you would have read this paragraph now, nothing would have gone inside your head, right? So coming to the topic, what is section 2(1)? Certification trademark. Certification trademark is defined in section 2(1)(e), which says that certification trademark means a mark. Certification trademark means a mark which is capable of distinguishing goods and service in connection with which it is used in the course of trade. Of course, it distinguish your goods and service, right? Like ISI, you know that if ISI mark is there in any industrial product, that product is of very good quality. You know that, right? So by using that mark, by using this ISI mark, you are able to distinguish your product from others. You are able to distinguish your products from others. But you need to certificate, you need to get a certificate which are certified by proprietor of the mark. Proprietor means who is the original owner of the mark. ISI authority, who are the owner of ICSI mark. Are we clear with this? ISI mark. So come again, that certification trademark means a mark. Certification trademark means a mark which is capable of distinguishing goods and service in connection with which it is used in the course of trade, which is able to distinguish it, right? And next, which is certified by the proprietor of the mark. In respect of what? Certification is done in respect of like origin or material. Gold में material के लिए ऊपर they certify ना, this is pure gold, right? Mode of manufacture, quality, accuracy, characteristics of goods and service, etc, etc, etc. Meaning that certification is done with respect to either origin of product or material used in the product, mode of manufacture, quality, accuracy, characteristics. So if you talk about the BIS logo or the hallmark logo, right? BIS logo or the hallmark logo, they certify that if in any gold instruments, sorry, jewelries or product, if in any gold jewelry this trademark BIS or a hallmark is used, it certifies that yeah, it is a particular material. It certifies that this is pure gold, certifies the quality that this is yeah good quality gold. Are you understanding? So here you certify what? You certify about the quality, quantity, original material, mode, characteristics of the product. Are we clear with this? Like this green dot and red dot, this also certifies that what material is used in preparing that food. Non-veg is used or only veg is used. So I hope now everyone is clear with the what do you mean by certification trademark, what do you mean by collective mark and well-known trademark. Now my dear, please don't get confused between the certification and the collection trademark, because collective बनने के लिए you need to be a member of that organization, like ICSI, CS. If I want to use the trademark CS, I should be the member of ICSI. Then only I can use the trademark CS. Certification mein you don't need to be the member. You just need to take a certificate from them. Can we use your trademark and they will allow you. Are you understanding? Certification mein you just need to take a certificate from them. They will do the checking, and if you comply with their requirement, they will give you a certificate that yeah, you can use green dot, red dot. You can use BIS, ISI. Are you understanding? Isme you don't need to be the member. You don't need to be the member. Anyone can take certification trademark by just applying to the authority, fulfilling with the requirement and getting a certificate from them. Anyone can use certification trademark. You don't need to be a member of that body. But collective trademark पे collective mark में collective, if you're using a collective mark may you have to be the member of that body. Like if I want to use CS, I should be the member of ICSI, then only I can use collective mark. Jaldi say let me know in the chat box, can I move forward? Are you clear with what you mean by certification trademark, collective trademark and well-known trademark? Yes. Can I move forward? Can I move forward? Jaldi say let me know in the chat box if we are clear till now. Can I move forward? Yes, everyone. Can I move forward? Are we clear till now? Yes, yes, everyone, just everyone, those who are watching the lecture, please give me a thumbs up or yes in the chat box. Okay. Yes, 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 yes. Okay. So I'm moving forward. I hope you all have understood what do you mean by certification, trademark, collective trademark, well-known trademark. Now, understanding thing is done. Now, procedural part is there. So I'll take it thoda sa speed. I'll take it thoda sa in a speedy manner. In case you don't understand, you can let me know. I'll slow down. But understanding thing is done. So now you have developed a base of trademark. What is trademark? What is well-known trademark? What is certificate trademark? What is collective trademark? Now we are good to go, and you have developed that base. about understanding about the trademark. Now we can take it thoda sa faster. Now the procedural thing will come, how you can apply, how you can get the trademark registered. That long, remember, patent long procedure we did. First we understood what do you mean by patent. Yes, in the last chapter, and then we did how you can register the patent, and that was a pretty long procedure, how to register the patent. Similarly, we'll be doing how to register trademark, right? Some definitions are given here, not very important. Assignment matlab giving your trademark to someone else. Let's say till now I have registered the brand name Apple with my name. Now I'm transferring that trademark in some other person's name. I'm giving some other person right to use that trademark. That is not an assignment. Giving your right to someone else in writing. Next is deceptively similar, matlab ekdam nearly similar. Yeah, deceptively similar matlab ekdam too similar. Example, Adidas, Evibars. Adidas, Evibars. Can I use Evibars also? No, I cannot use even Evibars also, because they are deceptively similar. Deceptively similar means it are too similar. Package matlab anything in which you package. Package can be um बॉक्स, कंटेनर, बॉटल, कवर, रैपर, चॉकलेट का, मेलेडी का रैपर, निविया की डब्बी, yes, folder, anything can be package. Package में anything in which you pack your product will come under package. No need to buy hard this. Everything will come in package. You just see package includes case also, box also, container, yes, covering, any covering, folder, receptacle, vessel, cascade, bottle, wrapper, label, band, any band, ticket, reel, frame, any frame, capsule, cap, lead. Even lead is bottle. मतलब आज से even lead is package. मतलब this lead आज से I'll call this lead. ओ भाई नहीं होगा. Even this lead I'll call package. Stopper, cock. No need, not very important. You can just have a see over it. Package mein everything will come, everything. You know why? Because you packaging, you can also get a trademark na, the way you are packaging your product, that also you can get trademark registered. That's why here the definition of package is given. Permitted use, easy only. Easy only. Permitted use means for which purpose you can use the trademark. Okay, permitted use matlab permitted use means for which purpose you can use the trademark, and the question is who can use the trademark. Registered user can use the trademark. Yes, registered user means, let's say, Yashas Academy. Yashas Academy, let's say Nilesh sir. Nilesh sir has uh, uh, taken the trademark in the name of Yashas Academy. So he's the registered owner of that. Okay. So the registered user. Nilesh sir has taken the trademark in his name. In his name. Yes, he has taken the trademark of the name Yashas Academy. So he is the registered user. Registered user means the owner of the trademark, the owner of the trademark. Who's the owner of Yashas Academy? Nilesh sir. Okay, so registered user means the owner of the trademark. So can owner of the trademark use trademark? Of course, yes. If owner will not use, who will use? I'm really sorry. Can owner Can registered owner use trademark? Yes, registered owner can use that trademark. Now the question is, can anyone else apart from the owner use that trademark? Yes. Any person other than the registered proprietor can also use trademark. Any person other than the registered proprietor can also use the trademark with the consent of the registered proprietor. What? With the consent. Let's say I am also providing classes, in the name of Yashas Academy. Can I provide that? Can I use this trademark Yashas Academy? Yes. Why? Because Nilesh sir has given me permission. So you know what? If anyone who is permitted by the owner, anyone who's permitted by the registered proprietor, that person can also use the trademark. So now we are doing section 2 1R, that is permitted use. Who can use the trademark and for what purpose? So number one, the owner can use the trademark in whose name trademark is registered. The registered user can use the trademark. Number two, any other person other than the registered user can also use the trademark with the consent of the registered proprietor. I hope everyone is crystal clear with that. Fuddu, not very important. You can, very Fuddu topic this is, you can just go through it. Okay. So now, number one, registered user can use it. Number two, any person other than the registered user can use it. Now, for what purpose? ABCD. These four things you have to take care. In order to use a trademark, you need to take care that you are using trademark in connection with your business. मतलब पर्सनल चीज के लिए यू कैन नॉट यूज दैट ट्रेडमार्क. यू कैन यूज दैट ट्रेडमार्क ओनली इन रिलेशन टू योर बिजनेस for which goods and service you have taken the trademark, or in respect of which trademark is registered specifically in respect of any goods and service. Like here we are studying in relation to which goods and service you can use a trademark, in relation to which goods and service you can use the trademark, in relation to which goods and service you can use the word trademark. Example, you can use that trademark in relation to those goods and service in connection with the course of trade. Example, you have taken Maggie as a trademark for noodles. Now can you sell your Kit Kat, Nestle coffee is also there, Nescafe, right? Nescafe coffee is of Nestle, if I'm not wrong. Right, so let's talk about Nescafe. So, can we sell coffee with the name Maggie? No. Why? Because Maggie, they have taken trademark for selling noodles. For selling noodles, they have taken this. Are you understanding? Please understand that you can use a trademark in relation to those goods and service which is connected to your trade, and number one, it should be connected to your business. You can use that trademark only in respect of that goods and service which is connected to your business and for which registration has taken. So for example, you have taken registration of the term Maggie, you have taken registration of the brand name Maggie, only for noodles, only for noodles. So you can use the brand name Maggie only for selling noodles. Now Nestle, who's the owner, even if he is the owner, Nestle is the owner of the brand name Maggie, but Nestle cannot use Maggie for selling popcorns. Why? Or Nestle cannot use the brand name Maggie for selling, let's say, for selling cream cosmetic products. We have taken the registration of Maggie, we have taken the registration of trademark of Maggie only for food items, let's say food items, right? Noodles and all food items. So can I use it for non food items? Can I use the term Maggie, Nestle, even Nestle, can Nestle use the brand name Maggie to sell phones? Can they make Maggie phones, Maggie brand name phones? No, they cannot. Why? Because there's a simple point given, of course, that registered users can use the trademark only in relation to those goods and service which complies with this four condition. Okay, four conditions are given. Only in respect of that goods and service you can use the word, you can use the trademark. Number one, it should be relating to your business. अपने personal property के लिए और personal thing के लिए you cannot use that trademark. You can use that trademark only in relation to goods and service which are relating to your trade. Trade means business, and you, in respect of which registration is taken. You have taken registration in that particular goods and service in that particular area. So food item में you have taken registration of Maggie. So now you can make food items with the name of Maggie. Are we clear with this? And number three, for which he is registered, जिसके लिए he himself is registered as the for which he himself is registered as the trademark owner and which complies with such other condition. So this four conditions should be satisfied, then only you can use that trademark for the respective goods and service. And same points are given for other person also. The trademark can be used by any person other than the registered owner provided following condition are fulfilled. It is used in relation to those goods and service, you know, which are connected with your trade. Number two, for which registration has been obtained. Number three, you have been given written consent by the registered proprietor to use that, and fulfilling such other condition as may be prescribed, such other condition as may prescribe. So these are same points except for the third point, because third point पहले वाले में दिया था कि he himself is registered, और second वाले में third point says that he has taken consent from the registered proprietor. Rest all is same. I hope permitted use is clear to you. I hope this definition is clear to you. What do you mean by permitted use? And what is service? Not very important. Service definition we have done thousand number of times in Copra also, Competition Act also, and many law. So service means any description, service of any description which has a potential users. This similar definition we have done in other chapters also. Copra also, I guess similar, only very chapri definition. Service, I'll not, no need to explain, I've explained this multiple number of times in Copra also. And Competition Act also, which says that a service means a service of any description or giving to the potential users, including some specific services are given, like banking is a service, communication, education, financing, insurance, chit funds, real estate, transport, storage, material processing, supply of energy, boarding, lodging, entertainment, abusing, construction, repair, news and advertisement. Same definition, you know, the same definition of services given in multiple acts, in many acts the same definition of service is given. So service means everything will be included in the service. I hope we are done with the definition part. Now come to the page number 51. Everyone please come to page number 51. Yes, everyone please come to page number 51. Okay. Now the question is who can apply. Now this is chapri. Now this is chapri. Any person who's claiming to be the proprietor of trademark, can he apply for the registration of trademark? Of course, yes. Now let's say we have a brand name Yashas Academy. We want to register Yashas Academy as a trademark. Who can apply for registering trademark? Nilesh sir can apply. Yes. A person who's claiming to be the owner of that trademark. A person who claims to be owner of the trademark, and that person applies to the trademark authority for the registration of trademark. Yes. Or even if that person is not applying, that person can apply through an agent. Yes. Let's say Nilesh sir appointed an agent, a practicing company secretary as an agent, and asked a practicing company secretary to file the trademark application on behalf of him. So can an agent also file an application for the trademark registration? Yes, of course. Trademark registration can be application can be filed either personally at the front office, matlab offline, matlab offline, or even online. Just go to the website, e-filing website, and there you can online file the trademark. You know what, most of the processing is done online only. And aajkal na, after covid, even government has turned completely online. No need to go and stand in the government queues and the government office. Even if you want to file any form or document or application to government, no need to go to that government office and stand in lines and wait for hours and hours. No, you can do it online also. Nowadays everything is online. Trademark registration is done online. And but offline also option is there if you want to submit. But you know what, even if you submit an offline application, ultimately the processing is done online only. They feed the data of that offline application in online, and rest of the process is done online only. And 98% of the applications have turned online, so most of the people are applying online only for the registration of trademark. Are we clear with this? Are we clear with this? So here please understand one point: who can apply for the trademark? Any person who claims to be the proprietor, that person can apply, or even his agent can apply. Kaise apply? Online also, offline also, it's up to them. Not very important. Are we clear with this? You can just have a read over it. Next, what are the different kind of trademark? This is already done. Already done, no need of further explanation. I have already explained you in very detail. Name can also be trademark. Example, SRK, SRT I gave you. Invented word. Invented arbitrary dictionary word. See, what do you mean by invented word? Invented word are known as coin word. Example, nowadays people are making the invented word, matlab, which does not have any dictionary meaning. They are making that new word on their own. Example, Zomato, Swiggy, Uber, Ola, Ole, Ola. My dear, if you'll see all this, do they have any meaning? No, they don't have any dictionary meaning. We are making a new word, Swiggy. Swiggy, is that does that have any dictionary meaning? No, that word does not have any dictionary meaning. We coined that word. Coined, matlab we invented that new word, and we are taking a trademark. Can we take the trademark of Swiggy? Of course, yes. Zomato. What is Zomato? What is Zomato? Tomato, pomato, or potato? What is Zomato? Right? Zomato is not having any dictionary meaning, but yes, we invented this word and we are using this as a trademark. So can any invented word be trademark? Yes. Arbitrary word matlab product is something else, you are using some other word. Example, blackberry. Blackberry phones are also there. Blackberry male clothing brand is also there. Blackberry clothing brand. Yes, Blackberry shirts are there. Formal shirts. Yes. So if you'll see Blackberry, berry is what? It is something which you eat. Blackberry. But you are using Blackberry as a phone brand. What is this? Arbitrary. Matlab, Blackberry is something else. You are using it as a brand of some other product. Example, very good example, boat. Boat. Boat is actually that choti si now through which you can go in water. Boat, using boat. But actually we are using boat as a brand name for selling earphones which have no relation. Earphones is other category of goods. Boat are other category of goods. We are using boat as a brand name of earphones. So this is known as arbitrary. Arbitrary matlab naam kuch aur and use kuch aur. Are you understanding? Arbitrary matlab boat is actual में something else, but we are using it for the brand of something else. Are you understanding? Paper boat. Example, paper boat. These are arbitrary words. Can you use arbitrary words also um, as a trademark? Yes. Next, letter or number. I've already told you this example of letter or number. Next is devices. Device also, you remember that Windows example I gave you. Fancy device also you can get registered as trademark. Monogram. Monogram means when you combine two or more letter to form one single letter. Example, Volkswagen, very nice example. Channel, this brand you must have heard. Louis Vuitton. Louis Vuitton. um, I could have my Gucci on. Yes, have you heard this song? Yes, of Megan Trainor. Okay, let's not go into that. Louis Vuitton. If you'll see Louis Vuitton, the trademark is just a combination of two letters. L V H P H P. Yes, just a combination of two letters. HP. Channel Volkswagen. Just a combination of two letters. New York NY. Yes, New York Stock Exchange. Please understand that monogram means combination of two or more letters, or when you make a symbol, single symbol by combining two or more letters, that is known as monogram. This also you can register as a trademark. Combination of color or even single color, that I have told you, MACD ka single color yellow is registered as a trademark, or even a single color or the combination of color like blue, white, you can register as a trademark. Shape of goods and packaging, I've already explained. um, 3D, 3D, 3D marks. You know what is 3D marks? These are the non-conventional marks. वैसे तो I've given a meaning of 3D from from research. So what do you mean by 3D design? Three dimensional. Three dimensional मतलब 3D design. We call any mark as 3D based on their shape, based on their packaging, and based on their sound. Like these are non-conventional. Non-conventional मतलब not traditional. New marks. 3D marks. 3D marks. So what is 3D? 3D are the non-conventional marks which are used in relation to shape of the product or its packaging or container. Example, I'll give you 3D ka. Arey, हाँ, yes. If you'll see this scooter, yes, super cub scooter of Honda. If you'll see this super cub scooter of Honda, the shape of the product. This they have taken a trademark. This is known as 3D trademark. 3D trademark any mark which is based on the shape of the product or the sound, or unique packaging, which is available in 3D design, that is known as 3D trademark. Example, expensive perfumes. Expensive perfumes, their bottles are so luxurious. Their bottles, their packaging, expensive perfumes, their bottles are so luxurious, they don't want any other brand to make exact same bottle like them. Like you can see here inside there is a man, you can see sitting. This packaging, this design is known as 3D design. And can I get this packaging as a registered as a trademark? Yes, I can. No one can copy this exact same design. There's no need to explain this bottles. Yes, this design, this is trademark registered. This is known as 3D design. Are we clear with this? Yes. So 3D signs also you can get as a trademark. Sound ka example, you tell me now some example of sound. Array, Windows ka, as soon as you open your Windows laptop, it makes some sound na, like um, every brand has a sound na. Array yaar, give me some example. Every brand, Whirlpool ka, Whirlpool, like this. Or every brand has a some sound. Pa 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 pa. Yes, yes. वन प्लस का रिंगटोन. अरे आईफोन का. डिडिंग डिंग 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 डिंग. ये आईफोन का साउंड कम लग रहा है. और ये हथौड़ी का डिंग 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 लग रहा है. ठीक है. व्हाट इज आईफोन का साउंड? अरे नहीं तो दिस इज तो अलार्म का. लेट्स नॉट गो इनटू दिस. बैक कर देते हैं इसको. मुझे कोई एग्जांपल दो यार. गिव मी सम एग्जांपल ऑफ साउंड किसी ब्रांड का, दैट साउंड स्पेसिफिक साउंड दे यूज फॉर द एडवर्टाइजमेंट में देखे होगे. आईपीएल का साउंड इज देयर. आईपीएल का साउंड इज देयर ना. आईपीएल का साउंड. गिव मी सम एग्जांपल्स ना गाइस. गर्ल्स एंड गाइस, गिव मी सम एग्जांपल्स. नेटफ्लिक्स का. हाँ, वेरी नाइस पिंकी. नेटफ्लिक्स का ठुडुम. यस, नेटफ्लिक्स का. लेट इस. चलो सर्च करेंगे तो बहुत ज्यादा टाइम लग जाएगा. लेट इस मूव फॉरवर्ड. यू हैव टू गिव मी सम एग्जांपल ऑफ साउंड. मेनी ब्रांड्स ऑफ देयर ओन साउंड. अभी कुछ क्लिक क्यों नहीं कर रहा? आई डोंट नो व्हाई. Okay. ठीक है, नेटफ्लिक्स इज अ वेरी गुड एग्जाम्पल. वन प्लस का रिंगटोन मुझे याद नहीं आ रहा है कैसा था, बट ठीक है, दैट इज ऑल्सो साउंड. यू नो, इवन म्यूजिकल नोट्स, द म्यूजिक दैट यू मेक, उसके जो नोट्स होते हैं, द नोट्स ऑफ द म्यूजिकल नोट्स, दैट साउंड मार्क, यू कैन गेट इट ट्रेडमार्क रजिस्टर. नो वन एल्स कैन यूज दैट सेम साउंड. नो वन else can use that same sound. Are we clear with this? Yes, yes, yes. Next, coming forward, procedure of registration. Now we are into the procedural parts. Now we are into the procedural parts. Okay, the procedure of registration. Now, I'll try to explain with the help of, come to this page. In next 3 4 pages they have given procedure only, so I'll try to take this thoda fast, because I've explained you already what is trademarked and all, everything. Now, I'll come to this page. Flowchart given in page number 54. In this page number 54, a flowchart is given. Come to this page. Now, if let's say I'm running an academy called, I'm running my classes with my name Ishika Agrawal classes. Now I want to get the trademark registration of Ishika Agrawal classes. I want to get the trademark registration of Ishika Agrawal classes. Then first of all, what you have to do, you have to make application to trademark registry. First of all, what you have to do, I have to make application to trademark registry. They will receive the application. I can make application either in offline mode or in offline online mode. It's up to me. Even if I make in offline mode, they will convert it into online. They will do the data entry online. They will digitalize my offline application. Even if I apply offline, they will do data entry of my application online, and they will digitalize it. And after that, they do Vienna codification. Vienna codification means it is a technique of checking whether anyone else has already registered trademark with this name. So if I am registering trademark with my name Ishika Agrawal, so I'll apply to the trademark registry that please register Ishika Agrawal as a trademark, so that no one else can use this word Ishika Agrawal. Okay, for that preliminary, when they will receive the application, they will digitalize the physical application, and after that they will do Vienna codification. Vienna codification means it's a software through which they check, they just search whether anyone else have already registered a trademark with the name of Ishika Agrawal. If it is a already registered trademark, I will not get that trademark. Are you understanding? In order to get that trademark, it should not be already existence or taken by someone else. If it is already taken by someone else, I cannot get Reliance as my trademark. Why? Because it is already taken by Anna, Mukku Anna. Are you understanding? So you do the Vienna codification. Through Vienna codification, you just search whether any other brand has already registered trademark with this name. Are we clear with this? And after that, when Vienna codification is done, preliminary we are satisfied that no other existing person has a trademark with this name. Then we will submit it for examination. And in this examination is done at two levels. This examination is done at two levels. First examination is done by examiner, yes, and second examination is done by controller of examination. Okay, so first examination matlab we will in detail, we will check that trademark, we will check that name, detailed research we will do. Okay, so here please understand that examination of application will be done. It is done at two level. First examination is done by examiner. If he is satisfied that your trademark is fine, he will submit his report to the controller. And if controller is also satisfied that yeah, everything is fine, they don't have any objection. Both of them, like it has passed through both the levels. Examiner also don't have any problem, and controller also don't have any problem. No, they have no objection. They have no objection. Now they will ask public for objection. Public का important है कि नहीं? Of course, yes. What if by mistake we have not any trademark is not yet registered, but let's say Yashas Academy, let's take an example. Yashas Academy is a brand name which we are using since last 20 years. Are you understanding? Since last 20 years we have developed a reputation called Yashas Academy, and we have developed a brand image. We have developed a brand image, a reputation of the Yashas Academy so far. But let's take an example. We have not yet registered with government. Let's take an example. We have not yet registered with the government for registration of the trademark of the word Yashas Academy. Okay. So we have not yet registered with the government for the registration of Trademark Academy. For the trademark of Yashas Academy. For example, I'm just giving you example that we are working since last 20 years and we have made a brand image of the Yashas Academy. But the thing is that we have not taken registration from government. Now some era gara nathu gara came. Mr. A. He opened an academy with the name Yashas Academy, and he applied to the government that I want a trademark with the name Yashas Academy. Don't you think government should provide opportunity to public Public, listen, government will publish it in the trademark journal. There's a trademark journal. Government will publish it in the trademark journal and ask for objection. So let's take an example. Let's take an example. Where was I? Yes. Let's take an example. Some other person, Mr. A. Mr. A came, era Gara Nathu Gara, started an academy Abhi recently he started academy with the name Yashas Academy, and he applied to the trademark registry for registering this trademark Yashas Academy. Don't you think we will raise objection? Arey bhai, you started yesterday. We are operating with the name Yashas Academy since last 20 years. This is our name. You cannot use it. So that is why, to invite public objection, कि this person is asking a trademark in the name of Yashas Academy. Anyone has any objection kya? Any people in India or any general public has any objection kya? So to invite objection from people, they publish that application in the trademark journal. So there's a trademark journal, online trademark journal. If you'll search now, if you'll go to Google and you will search trademark journal, it will come. See, in the website of ipindia.gov.in. The website for intellectual property rights is ipindia.gov.in. If you'll open this website here, you can see trademark journal. They have published it. Date of publication, when did they publish it? 25 September, yesterday only. Date of validity, let's see. Class 1 to 6. Let's just check. They publish it in the trademark journal so that if any public has any objection, they can object to that. Trademark, this is trademark journal. You can say IP, intellectual property, India, IP India. क्या है ये? भगवान, छोड़ो इसको. अच्छा, ये रहा. Kingston. Some person has applied to register the trademark of this Kingston. This image you are seeing, this logo you are seeing. Someone has applied to register this logo as a trademark. Now you can see the details here. Who has applied? Mr. Kingston Multi Products India Private Limited has applied for this. And what kind of product they provide? They provide adhesives, chemicals, and urethane sealant, etc. product which falls in class 1. So this you can see. Are you understanding? Are you understanding? V guard, whatever. Santosh, Santosh Scientifics. This is a company of Chennai, and they have applied to register this trademark. Santosh Scientifics, they have applied to register this trademark in the name of Santosh Scientifics with this brand name. कहाँ गया अरे भाई? Santosh Scientifics. Are you understanding? Are you understanding? Let's close this and come back to the topic. So my dear, they publish it in the trademark journal. So you know what, all the publications which I just showed you, they have not yet been given trademark, but that is just public to get our objection. So let's say Santosh Elect Scientifics, I have already registered a trademark Santosh, or I'm already using Santosh Scientific's name before him only. So I have any objection, I can raise that objection to the trademark authority, right? So two things can happen. When the objection is done, either no objection is there, in that case they will register my trademark, and if any objection is there, then the hearing will be done proper. Both the parties, sunwai will be done, hearing will be done, and after hearing, two things can happen: either they will allow my registration or they will reject my application. If they reject my application, then I can go for appeal or review. I can apply for appeal or review. Now coming back here in the examination level, what if they have any objection? What if the examiner or the controller has any objection? They are not satisfied, they only have any objection. If the examiner has any objection, they will not even publish it in the journal. They will respond you back, and they will raise objection, and they will get a response from you. They will raise objection and they will get a response from you. And even if they are not satisfied with your response, yes, in that case, if the objection is not waived off, it will be rejected. your application will be rejected. And if your application is rejected, uh, if objection is not waived off, application will be rejected. And if your application is rejected, you have an option to file an appeal or review. So I hope that you are clear with this picture, because this, this is process ko खींच ke they have given in 3 pages. The same process, by stretching it, the same process they have given in 3 pages. Right. So I'll just quickly explain this process again. First, I'll make an application to the registrar of trademark. They will digitalize it, do the data entry, and do the Vienna codification. Through Vienna codification, they just initially check whether anyone has already registered trademark with that name. After that, they will submit it for examination. Examination is done at two level by two people, one examiner, another controller. If both of that them don't have any objection, then they will publish it in the trademark journal. However, if they have any objection, they will ask the person to respond. And if after responding the response of the person, they are okay, they are satisfied, they will publish it in the trademark journal. However, if they are not satisfied with the response, they will reject the application, and then you can file an appeal. Okay. However, if they are okay with the response or they are satisfied, then they will publish your application in the trademark journal. Now, for the objection by the people, two things can happen: no one has raised any objection, no objection is there, then your trademark will be registered. However, any objection is there and they win, objection is allowed, then your application will be cancelled, and in that case you can go for appeal. I hope that you are clear with this chart or this process of application. इसी को खींच खींच के ना खींच के literally खींच के they have given in 3 4 pages. Very quickly come here, section 18. Section 18 deals with process of registration, which says that any person, highlight only that one, how much I have highlighted. Any person can apply in writing. Of course, you have to apply in writing to the registrar of trademark. In which form? TMA. Write the form number. In which form you can apply for the registration of trademark? In the form number TMA. In the form number TMA. In the form number TMA, right? So here one point is given that you shall apply in writing to the registrar in the form number TMA for the registration of the trademark. Now, registration in different classes of the goods and service by means simple application. Now, one very important thing I'm going to tell you. Yes. Can you see here VPO? VPO. I have told you VPO, it is an international body of UN, United Nation, for regulating intellectual properties internationally. VPO, right? VPO has made a method of classification that is known as NICE classification. NICE classification it is known as. Now, what is NICE classification? They have classified all the category of goods in 34 categories, and they have classified all the category of service in 11 categories. So category 1, if you'll see class 1, category 1 mein what all will come? Category 1 mein na chemical products will come. Chemical, science, photography, artificial resin, horticulture, forestry, fertilizers, biological preparation, all this thing will come under class 1. Now let's see class 2. Let's just check class 2. Class 2 may plant, varnishes, lacquers, whatever, plants, painting, decorating, painting, dyes, ink of painting, engraving, raw material, design, etc. All this thing will come. Let's see category 3. Category 3 में non-medicated cosmetics and toiletry products will come, laundry products. Let's check class 25. Class 25 में clothing, footwear, headwear. Clothing, footwear which you wear in your foot, and headwear, hat and all. This three thing will come in class 5. This three thing will come in class 5. So my dear, class 5 you can see here clothing, etc. So many class are there. Let's just see class 34. Class 34 comes in this, what kind of products come? Tobacco substitute, cigarette, cigar, electronic cigarettes, oral vaporizers, smokers article, matches. You're right. So in class 34, all this product come. My dear, please understand that I want to tell you in the top of the page or previous page, I guess you have some space. In the page number 50, you have some space. You can write here that VPO has done a classification of goods and service. They have made nice. classification. Nice classification of goods and service. Inside that nice classification, they have classified goods into 34 categories, which is 1 to 34. And they have classified services as 11 categories of service, which are 35 to 45. 35 to 45, 11 happened na, 11, 35 to 45, 11, and 1 to 34, 34 categories. Are we clear with this? Now, my dear, very important thing I want to tell you. Please listen, very important thing. When we register a trademark, we have to select in which class you want to register. In which class? Like for education, let's see what is the education is a service, right? So it will come somewhere between 35 to 45. So let's see where does education comes. 35 may comes art, advertisement, business management, etc. Office functions. 36 में financial and all in real estate insurance comes. 37 में constructions and all come. 38 में telecommunication comes. 39 में transport packaging travel comes. 40 में material treatment waste air purifier comes. अरे भाई, where is education? Food and drink. Ha, 41. You can see here. Education comes under 41, right? Education comes under 41. Education, providing of training, entertainment, sporting and cultural activity. So all these activities comes under class 41. Okay, so education, training, entertainment, sporting, cultural activity. This comes under class 41. Now listen very carefully. We as a Yashas Academy. Okay, so Yashas Academy, we want to get a trademark of Yashas Academy. So for getting the trademark of Yashas Academy, we are applying to trademark registry. Trademark registry, please register this trademark Yashas Academy. So they will ask me, sir, in which category you want to register your trademark Yashas Academy? Like 1 to 45. Total 45 classifications are there. Out of 1 to 45, which category of goods and service you want to register your trademark? And you know what? For separate categories, different fees is there. So let's say if I want to register in two categories, I need to pay double fees, different fees is there for different categories, right? So let's say I don't want to register in all the categories, I only want to register in education category. So I told them, class 41, please register my trademark Yashas Academy in class 41. In class 41, you know what, you register your trademark with respect to a particular class. You have to tell that while applying. A list is available already which class is there, so we can already know that education comes under class 41. So while registering our trademark now, we have to select that which particular class I want to register. So I selected that in class 41 we want to register as a Yashas Academy. Are we clear with this? In class 41. In class 41. So now please understand, if we have registered Yashas Academy, or the word Yashas is used only in education, can someone open a canteen with the name Yashas? Yashas Canteen. Can anyone open a canteen? The answer is yes. Why? Because food is a different category, education is a different category. We just saw that food comes under different category, right, of goods and service. So please understand that if you register your trademark with respect to a particular class, your trademark is protected only in that class. In other classes, anyone can use that name. Example, if the word Yashas we have registered only in the education class 41, it is not registered in food class, right? So if anyone want to do food business, let's say someone is selling dosa, can they use the word Yashas Dosa, Yashas Canteen, Yashas Dosa? Of course yes, they can do so. Why? Because the word Yashas is registered only in the category of education. So while registering now, while making application, you have to select in which category you want to register. Are we clear with this? Yes. Are we clear with this? So I hope you have written this. One best example I will give you of this particular thing is VIP. VIP. VIP is a brand. Yes. VIP is a brand. Very good example. I'll tell you. VIP. VIP is a brand. Yes. You know what does VIP makes? What does VIP makes? Number one, they make suitcase also. Luggage. Luggage. VIP suitcase comes na? Luggage. Next. They make undergarments also. VIP undergarments. Yes. Yes, VIP undergarments. So VIP, if you'll see a brand, VIP is a brand. Is the same brand which is making the suitcase and the undergarments? Of course not. Of course not. There's a different company or the different brands, different company who is there's a different company who is making VIP undergarments, and there's a different company who's making a VIP suitcase or luggage. Are you understanding? So please understand that since this VIP suitcase luggage, they registered their trademark only in that category. They did not register their trademark in the clothing category. Are you understanding? So that is why can we use this brand name for clothing? Yes, of course, yes. It's possible that this undergarments company has taken VIP trademark in the category of clothing, and the suitcase or luggage a company which is making VIP suitcase, they have taken the trademark of VIP in the category of that suitcase or luggage products. Are you understanding? So the uh, trademark you take with respect to a particular category. Acha, can we take a register our trademark in more than one category? Yes. You know what? SRK. Shah Rukh Khan has taken his name trademark SRK in almost all the category. Like out of 45 categories now, he has taken in almost like more than 35, you can say. In major of the categories he has taken. Can we do so? Yes. This category may you want, you can take registration. The only thing is fees will be very hefty. You know what? If I want to take Yesh's Yesh's trademark, I want to take only in education category, only in class 41. So I have to pay fees for one category. Now let's say I want to register Yesh's trademark in our name in all the categories, so that no one will do any business anywhere. No one will do any business with the name Yesh's. So I have to apply in all the 45 categories, in all the 45 classes, and I have to pay the separate fees. I have to pay the separate fees for the 45 classes. Can I take the registration in different classes? I can take. The only thing is you have to pay fees separately. Ma'am, by single application, can I apply for registering my trademark in multiple classes? Yes. You don't need to apply separately. By single application only, by single application, by one and only, by single application only, you can register your trademark in multiple classes or multiple categories. Like, Sony. Sony, Sony, ओ सोनियो नहीं, I'm not talking about the सोनू निगम का सोनियो song. Sonio, I'm talking about Sony brand. Sony is an electrics brand. Yes, electricals brand. uh, yes, they make computer, laptops, TV, etc, 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 electricals brand. So you know what, there was a company which was making nail paints for women. I don't apply nail paints, ठीक है, but there was a company which was making nail paints for women. Matlab, men can also use that, but majorly women uses nail paint. So there was a company which was making nail paints and using the brand name Sony. They were selling Sony nail paints, matlab brand name Sony, and they wanted to register a trademark Sony for the nail paints. So here, law said that this, of course they can use that. Of course people will not get gumrah, or people will not confuse that is this the same brand Sony which is making electricals also, which is making nail paint also. Of course not. We have that much common sense, right? So even if we allow the use of the brand name Sony for making nail paints, is perfectly fine, because electrical is a completely different category. Nail paint is a complete different cosmetic category. It will come under cosmetics category. So cosmetic is a different category, electricals are the different category. So law allowed here the registration of the word Sony as a trademark for nail paints under cosmetic category. Why? Because it is pretty obvious that if Sony is making electricals, and if we allow Sony name to the nail paints, yes, if they are not registered under cosmetic class, yes, so if we allow Sony name to be used by a nail paint brand, it will not create any confusion in the mind of consumer. Like if I'll go and purchase Sony nail paint, I'll not confuse that whether this brand is same like the one who sells Sony ka TV. Are you understanding? There will be no such confusion. That is why law allows that if Sony is registered in electricals, then you want to register the same name Sony for nail paints or cosmetic business. Can you? Yes, of course you can. So I hope you are clear about the classification of the goods and service for the purpose of trademark registration. I hope that you're crystal clear about the classification, and this is a nice classification, and I see this is not Indian classification. This is given by WIPO, which is international body. I have already told you about WIPO. This is an international body, WIPO. Yes, Avik love with this. Now come here. Oh God. Yes, now come here. Registration in several classes of goods and service by mean, can you register in several classes by single application? Yes, you can. Just that you have to pay the separate fees for different classes. Registration of separate classes, you want to register in different classes of goods and service by single application, can you do that? Yes, you can do that. You know this you can cut. Abhi, you can cut this, and abhi ke liye don't write this, don't write because it will come again. So abhi ke liye you can cut this para and itna. So now My dear, you want to submit an application? Yes. For the registration of trademark, you can submit in the form number TMA, and after that, they will do the processing. Not very important. What they will do the processing of the trademark, and this processing is done completely online through a system. There's a proper software system called TM Electronic Processing System. There's an online system, online software system which the use trademark registry use. That is known as Trademark Electronic Processing System. So all the application that we receive, we process this electronically only. Even if we receive physical application, we convert it in electronic, and the processing is done as electronic mode only. 98% people are started filing electronically only now. Not very relevant. After that, the process is given. First is pre-examination processing. Please understand that first is we will make the application. Application can be filed either online or offline. And if it is filed offline, then we digitalize the application. Matlab we convert it online. After that, Vienna codification is done. I have already told you Vienna codification is, it is a software process through which we preliminary check whether anyone else has already registered this trademark or not. We will just check that whether this name is taken or not through a software, and that is known as Vienna codification. Mm. So Vienna codification means codification of the figurative elements is done as per Vienna agreement, and you know this Vienna codification is done as per the agreement, international agreement, which is Vienna agreement. A discussion, a name of Vienna agreement came even in the first intellectual property chapter. Are we clear with this? And then application moves for examination. So after Vienna codification is done, we then submit it for the examination. After that, examination is done at two level. Are we clear with this? Examination is done by automated system. It is done in two stages. First examination is done by examiner, and after examiner is satisfied that everything is okay, he will submit his examination report to the examination controller. So first examination will be done by examiner, and then he will submit it to the controller, and then the second examination will be done by the controller. I have already taught you this from the chat. In case you don't understand anything, you can let me know in the chat box. Are we clear with this? Yes. So first examination will be prepared by the examiner, and then he will forward that to the examiner controller, and thereafter examination report will be issued. Two things can happen. Either, let's say, examiner, please understand that different situations are given here. Let's say if examiner is satisfied everything is okay, he will submit that to the examination controller. If controller finds some deficiency, if some deficiency is noted by controller, if any deficiency is noted by controller, he will refer that back to the examiner, that check again, I found some deficiency, please check again and revert back to me. Are we clear with this? And if any objection is raised, if any objection is raised either by examiner or by controller, if any objection is raised, they will again submit back the application to the applicant, and they will ask them to make the changes. For example, I made an application to I made an application to the government, to the registrar of the trademark, to register the trademark with my name Ishika Agrawal. Okay. So they will do the application, Vienna codification, and then examination will be done by examiner. Let's say he find everything okay. Then controller found some objection. Then he will give it back to the examiner. Now let's say examiner again found some objection. Then they will submit that application back to me. They will ask me, madam, we have some this objection with your application. This is not correct. Please rectify your application and submit us back within 1 month. Are we clear with this? Within 30 days. They will ask me that, ma'am, this objection we have, and this is not appropriate. We have this objection. You rectify it and you submit it back. Okay, in that case, 30 days time limit is given, 1 month time limit, and I can submit back by rectifying the objection. Are we clear with this? Yes. However, if both the people are satisfied with the examiner is also satisfied and controller is also satisfied, everything is okay. So if they accept the application, then they will publish it in the trademark journal. Otherwise, else means otherwise otherwise what they'll do, they will issue the application back to the applicant and ask him to reply within 30 days. If they found any objection, they will return back my application to me and ask me to make changes and submit the revised certificate within how many days? Within 30 days. After that, post examination is done, and let's say everything is not okay, and they have asked me to resubmit the application. So they will consider my reply, they will ask for my reply, and I have to reply within how many days? I have to reply within uh, 30 days. I have to reply within 30 days. So applicants needs to submit a reply within 1 month, and if he fails to, the application will be abandoned. If I don't reply within 1 month, the application will be abandoned. Are we clear with this? However, if I do submit the reply within 1 month, they will consider my reply, and after my reply, they are satisfied, everything is okay. If they accept my application, then they will publish it in the trademark journal. Then they will publish it in the trademark journal. And however, if they don't accept my application, let's say they are not satisfied with the examination report, or they are not satisfied with my reply, then in that case they will give me opportunity of being heard. Hearing opportunity they will give me. Hearing will be done. Both parties will be heard. They will give me hearing opportunity, and after that they will cancel my application. They will cancel my application even if they are not satisfied. Are we clear with this? Yes. Next. I'm really sorry. In other, okay, okay. Okay. Now show cause notice. Show cause hearing means if objection is raised by office that you are not meeting the reply, or your this objection is raised at the first stage only. First stage only matlab where, if this objection is raised here only during the examination stage. During this examination stage, if any objection is raised, hearing will be done. They will issue me show cause notice. Hearing will be done, and both the parties will be heard. So come here. If any objection is raised by the office that you're not meeting with the reply, or you're not meeting with the condition, then they will issue me so cause hearing. Hearing will be done. Notice will be issued to me, and after hearing, two things can happen. If they are satisfied, they will move it forward and publish it in the trademark journal. However, if they are not satisfied, then they will reject my application. Are we clear with this? Next is, what if everything is okay, the examination report is fine. Let's say the examination report is fine. So if the examination report is fine, or they are satisfied with my reply, in that case they will publish it in the trademark journal. Now here we are inviting objection from public. Any public has any objection kya? Are we clear with this? So now here please come post advertisement processing. Post advertisement matlab, if examination report is fine, then you will publish it in the trademark journal. Now people will can file objection within 4 months. People can file objection within 4 months. You have to remember this date, 4 months. However, if no opposition or no objection is filed within 4 months from the date of publication, in that case they will register. They will register the trademark. The trademark will be registered. However, if any objection is issued, if any objection is issued by third party, then proper hearing opportunity will be given. Both party will be heard. Two things can happen. Two things can happen. I win or my opposition win. If I win, they will register my trademark in my name. If I do not win, my opposition, those who raised objection, they won, then they will cancel my registration. Are we clear with this? Yes. However, if the opposition is dismissed, agar wo phudu nikla, if opposition is dismissed, then they will register trademark in my name. However, if opposition is allowed, then they will refuse my application. Are we clear with this? Next, what if everything is okay, no one raised any objection, or even if anyone raised any objection, their objection was cancelled. I won. In that case, they will register me. So when they will register my trademark, now they will issue me a certificate. Certificate of trademark, which is known as yes, they will issue a certificate to me, which is a conclusive proof that I have a valid registered trademark. They will give me a certificate. Are we clear with this? Now, post registration matlab, after registration, if any changes happens, na post registration matlab, you are successfully registered as a trademark owner. Now if after that you want to make any changes, you need to inform, like changes like a change in name, address, service assignment, anything of the registered user in the registry of trademark. You have to file a request form. You have to file a request to the registrar to make that changes. Are we clear with this? Yeah, an officer will examine and raise objections if any. Then you have to reply. No, no, no. And then they have to process the application within 30 days. Within 30 days. In case it is also a practice of the registry to send 1 month notice, 1 month notice to the previous registered owner in case there is a change in any proprietorship by way of assignment or transmission filed by the applicant. Very nice line is given here. Please mark from here, mark from here till here. Very nice line is given here. Uh, or you can say from till here. Yes, till here. Here one point is given. What is the point, my dear? Uh, One point is given here, that that if after registering the trademark any changes happen, changes in the owner, changes in address, assignment, anything, you have to immediately file a form and you have to inform the registrar about the changes, and they will process within 30 days. However, one extra point is given here. If owner is changing, let's say I was registered with a trademark Maggie, now I'm giving this right to someone else, I'm assigning this right to someone else, right? The ownership is changing. Then the registrar, trademark registry, or the registrar will give 1 month notice to the Nestle, will give 1 month notice to the previous owner, that are you satisfied, are you serious, you are actually giving your trademark to someone else. And if they have no objection within 1 month, then only that assignment will be done, or it will be registered in the new person's name. Are we clear with this? Are we clear with this? And we have to wait for 1 month. We will give 1 month time to the previous owner. Let's say previous owner of Maggie, Nestle, we will give 1 month time to Nestle to object to this. And we will ask him, are you serious, are you only transferring your brand name to Mr. A, or he has infringed your rights? Are we clear with this? So in case the proprietor is changing by assigning, in that particular case, uh, we have to file that, the sorry we have when you make application to registrar will give minimum 1 month notice to the original or the previous owner, and only after the expiry of 1 month that can be proceeded. Are we clear with this? That is all about post registration, and we are done with this. Benefit of trademark registration, खुद only matlab, exclusive right we get to use that product, no one else can use. We can use the symbol R, and we can seek the relief for infringement. If anyone uses my trademark without my permission, that is known as infringement. So I can seek relief, I can file a case, subject to condition, right? So all these things are given. That what is your right? You have exclusive right to use that product, to seek infringement, to use the symbol R. Now my dear, please understand that, one additional thing I want to tell you, the additional thing that I want to tell you is, uh, some brands, if you can see here, some brands have a TM in their brand name trademark, or some are using R. If you see now, like here you can see there is a R, there is a R trademark mein, there is an R. If you see now, R, R means some trademark uses the logo R. Yes, some trademark uses like this R, and some uses trademark like this TM. What is the difference between the two? R means your trademark is registered. If you are using TM means you have applied for registration but not yet registered. Not yet registered. You know what? It takes more than a year. It takes more than a year. It takes multiple years. अभी तो फिर भी it is थोड़ा सा speeden up. Earlier though it used to take 2 years to register a trademark. So let's say today I have applied for the registration of my trademark. I have to wait for 2 years, 1 year, 2 year. It take 1 year or 2 year to register trademark. Till that time, when I have applied for the trademark, but I have not yet got trademark, so I can use this word TM. This shows that temporary mark. Temporary matlab it is not yet registered, but yes, I have applied for it. And once my trademark get registered by that registry, then I can use this word R. This sign R, gola, R circle, this is the sign of registered trademark. And when you see TM circle, this is the sign of unregistered trademark. You have just applied for it, and you are not registered. So what is the benefit of registering? The benefit of registering is, as soon as you register, you can use the symbol R. Are we clear with this? However, if two or more person has registered with the similar marks, then you don't get exclusive right against that person. Two or more person has registered with the similar marks, let's say Tata Bata, then you cannot use exclusive right against Tata. वैसे तो you have exclusive right, but if some other company also has registered similar trademark in your name, then you don't get exclusive right against them. Chapri baat only. Benefit of registration, very much chapri, very much chapri. Now before doing this, I'll give you a break. Now before break, I want to just discuss just one very small point, which is registration. Come to page number 59, please. One very small point I'll tell you. After that, I'll give you a break. I'll give you a break. Yes, we'll have a break. Come to very, very small point, registration. See, we are just doing the process of registration, right? When we make application for registration and that application for registration is accepted, and either it is not opposed, or even if it is opposed, it is opposed, the opposition has been decided in the favor of applicant, meaning you have made an application for registration. Remember process we are doing. You have made an application for registration. Either it is not opposed at all, no one opposed it, or even if it was opposed, it was decided in our favor. In this cases, registrar will register our trademark within how many months? 18 months from the date of application. It is compulsory that registrar will register within 18 months. Within 18 months of filing application, he has to register your trademark. He has to register your trademark, and within 18 months the trademark will be registered, and the date of the date of uh, and the trademark when registered shall be the date as on the date of making application of the said trademark. Very nice point here is given, that date that shall be deemed to be the date of date of registration. Let's say I applied today, 26 September 2023, for the registration of trademark. But my trademark registered on, let's say, 26 September 2024. 2024. So on, as on what date it will be considered that my trademark is registered? As on the date on which I applied, and not on which they registered. So backdated the register, matlab they will register my trademark effective from the date of 26 September to 2023, because I applied in 26 September 2023. So the trademark will be registered from the date of application and not from the date of actual registration. Are we clear with this? And lastly, when they will register my trademark, they will issue a certificate of trademark to me in the form number RG2. They will issue a certificate of registration of trademark, and which should be under the seal of trademark registry, which will be under the seal of trademark registry. They will issue me a certificate, and that certificate will be in the form number RG2. Have we clear with this? Yes. However, if registration is not complete within 12 months from the date of application by reason of because 12 months ni 18 months, sorry. This is 18 months. 18 months time limit is given, that registration should be done within 18 months. However, if let's say registration is not complete within 18 months because of the default of applicant, he did not cooperate it, he did not give any information which was required. In that case, if because of the default of the applicant we are not able to register within 18 months, then registrar may treat the application as abandoned. He will abandon the application. एक तो you are not, we are asking information, you are not giving information. Application cancelled. Application abandoned. Are we clear with this? However, after granting the trademark, a registrar can also amend or make a changes in the certificate of registration if there is any error or any mistake. To rectify that any error or mistake, amendment can also be done. So this is a basic point, that registrar will register within 18 months and will give a issue certificate of registration in the form number RG2. So with this we are done with the whole process of registration of trademark. With this we are done with the whole process of registration of trademark. Please let me know, are we crystal clear with what we studied in the first half? Please let me know, everyone, those who are watching the lecture, everyone will drop me a message in the chat box. Are we crystal clear? Can we have a break? Are we crystal clear? Yes. Yes. Are we crystal clear? Everyone crystal clear kya? Everyone crystal clear with what is the process of registration of trademark? Yes, everyone crystal clear? Yes, Amulya, Sanjita, Kiran, Chandana, Ananya, Pinky. Yes, what about others? What about others? Yes, what about others? Everyone. Yes, what about others? Yes, Sharat, Rishika, Priti, Kishan said yes, David. Yes, everyone, yes? Okay, okay. Great. Okay, so with this we are having a break, and we'll have thoda sa long break. So we'll resume at around like 11:30, and we can take our class thoda late tak bhi, because it's a holiday, and you are at your home. So at your comfortable position at your home, you're watching the lecture. So we'll have a thoda sa long break, and we'll resume at like 11:30 or so. Okay, 11, 11:30? No, sorry. Yes. 11:30 we'll resume 11:30. Till 11:30 you have a break, and we will extend our class थोड़ा सा. Okay. Yes. Okay. बहुत ज़्यादा नहीं, थोड़ा सा, स्वल्प स्वल्प, स्वल्प स्वल्प. So I hope you are clear with what we studied. We'll continue with this chapter after the break, and rest easy topics are remaining. No, one topic is not easy. Section 9, section 11. वैसे तो most of the topics are easy only. Some topics are technical, but we'll do this after the break. Okay, let's have a break. Have a good tindi aita. Okay, take care. See you after the break. I'll drop you a message in the Telegram. Do on your Telegram notification when I start the session. Okay, take care. See you after the break.